Last year, a petition seeking rules to register live-in relationships was dismissed by the Supreme Court of India, with Chief Justice D.Y. Chandrachud calling it a harebrained idea. The lawyer had filed a PIL calling for guidelines for mandatory registration of every live-in relationship in the country. The petition also sought social security for couples living together. Cut to now, Uttarakhand Uniform Civil Code bill that was tabled in the State Assembly today stipulates registration of live-in relationships in the state and imprisonment of 3 months in case if one fails to do so. Now, individuals in or planning to enter live-in relationships in Uttarakhand must register themselves with district officials once the Uniform Civil Code becomes law, with parental consent required for those below the age of 21 who wish to live together. This is what the bill says. Now, the UCC in Uttarakhand is being seen as a precursor to similar laws in other states. Live-in relationships in India don't have legal recognition, but the Supreme Court over the last few years has recognized personal liberties of individuals involved, and in a number of judgments has given live-in couples certain rights. For instance, live-in relationships can be covered under protection from domestic violence law. So does the obligation to register a live-in relationship go against principles of privacy and the promise of freedom that are enshrined in the Constitution? How will this impact lives of young people in love? That is the question we are asking tonight. Joining us now, Khushbu Jain, Advocate Supreme Court, Dr. Akriti Bhatia, who's a sociologist, and Ashutosh Shrivastava, who's an advocate of the Supreme Court. Thank you all of you for joining us on this broadcast. Let me go across to Ms. Jain. As a lawyer, tell us, what is the legal status of live-in relationships in India? What have the courts said? And how do you see Uttarakhand bill in this context?
Okay, so as of now, live-in relationship in India is legal. There is no harm when it comes to legal relationship. Not been given a status of criminalization of live-in relationship, but there has been okay, and we have not seen, this is something which is new in India as compared to Western culture, but we have seen that this is turning out to be a matter of personal choice, that somebody wants to have a live-in relationship for reasons that can be to check compatibility, to understand, or it can be anything to understand the harmony part of it, or there can be enough of more reasons to understand, to spend quality time, to check the duration of the relationship before entering into a marriage, or to help build in unity in diversity, and to understand that part, or to remove any kind of social pressure that comes in place once you break a relationship. So these are the fabrics that has given a rise to live-in relationship. Now, coming to your question, and when it comes to court, there are a lot of areas where court rights to the people who are living in who are in a live-in relationship, and those rights include that in the event of maintenance, in the event of domestic violence, they have been considered as a relationship and been put in. But coming to your direct question as to how do I see it when it comes to UCC draft issued by Uttarakhand, I do not completely agree on that specific aspect as the aspect of must, that it's a must for a couple to register. Yes, it can be an option where couple want to register it, because there are instances where people are being disturbed by locals or by police or by somebody else. In that scenario, if they need that kind of a security, that's a choice which personally the couple should make it. It should not be a compulsion by the state.
Right. Ashutosh Shrivastava, would you agree with what Ms. Jain is saying? Because, the bill clearly says that even a delay in registration by just a month will trigger a jail term of up to 3 months or a fine of ₹10,000. Does this stigmatize live-in relationships, or, as some people are saying, just adds a layer of security?
I can agree to my learned friend, to an extent, but, making everything optional, then nobody will get get it registered. See, the purpose of this rule would be to minimize, many unwanted relationships, also illegal, or maybe, prohibited relationships. We have seen many such live-in relationships are, being continued where they are into prohibited relationship. Then there could be instances where somebody would have been taken by forceful consent. And if the woman has been taken and being kept by a forceful means. So all these things will be clarified if it is properly notified with the registrar. So
Right.
the actions can accordingly be taken, and the registrar or the government will be totally, in sync with the couple, that they are staying together with their own consent and free will. So there is no force in either of the,
Right.
partners. And in addition to that, the rules which have been made, like, the person should be unmarried, or maybe, not having a legally wedded
Right.
a wife or a husband at that time. So all these
Okay.
things are required so far as the morality or the public policy of our country are concerned. That has to also be seen from the point of view of legalization of, live-in relationship, and also the children. Many times when the children are born, they have to be legitimate, because the children should not suffer out of such kind of relationships.
Khushbu,
So
I'll
I
just
think the
come to
government.
you. Dr. Bhatia,
Uh,
let me just bring you in here. Now, I know that a lot of laws are brought in the garb of, women's safety or protection for women. Now, in the last few years, we've also seen a rise in intimate partner violence, or it could be just, a rise in reporting. So what kind of support can we give to women, especially young women in relationships that are not often accepted by society or their own families? And how does a law like this even help, or does it even help?
No, so thank you so much for having me. This law is actually, I would say, very unlawful and unconstitutional, because it violates the fundamental right to freedom of choice, of right to privacy. And this is not something that I am saying. The Supreme Court in various verdicts has said that living together as partners without getting married is not illegal or a criminal offense. And given that if majors are involved and there is consensual relationship, uh, this kind of a paternalistic and moral policing is something which is not something that the courts have, as precedents stated. Also, if you look at this very recent same-sex marriage verdict, even there it was stated that marriage would bring in a lot of other legal recognitions, but living in or cohabitation was something that
Right.
was permitted. And in fact, it was stated that the police should not enter into any kind of persecution amongst for against such couples. So this is something that is actually anti-women. It is anti. It is not something that and the person who was just speaking before me, sir, you said that this will avoid
Right.
forceful uh, uh, forceful relationships. In fact, this is against people who are consenting. Also, this still permission kind of a thing. This is again something that even if marriage is happening, the courts have said that parental permission, if there are majors, is not needed. So why such a thing for
Right.
live-in relationships? People are marrying late these days. They're working, and a lot of such arrangements have become very.
Right.
Cultural ambiguities
Let
will
me get
also
across.
take place. When you
Let me
actually
get in
visit each
Khushbu Jain
household.
here. Khushbu, would you agree with that? And also, there's another point of minors. In the last few months, we've also seen courts being sensitive when it comes to young adults. Where the boy is slightly older than the girl, who could be a minor, and they've eloped, and families have charged the boy with POCSO and other laws which are actually brought in to protect children. How does one balance realities of women getting cheated versus families going to all extents to separate couples, even misuse laws?
Okay. See, there cannot be a straightforward answer to that. But if you have to understand, yes, we have seen in the past, and I think there was a discussion at NDTV itself when it came to women at the younger age, or at minor age, or just across the age, and there is a huge age gap when it comes to the other partner living in a live-in relationship. Maybe with the aspect of promise of marriage, or luring, or showing a life which making them live in that life and taking an advantage of it, which they do not understand that they are being taken advantage of. These things, there can be chances of happening it, but this has happened in the past as well. If you look at our marriage, age has never been a question when it comes to marriage. There has always been a gap in the age. But yes, there is an element of this happening, but you cannot say that force upon. That's where I'm putting it across, that the aspect of forcing couples to register is something which is not right. And in the event of not going and giving them a jail term is something which is literally draconian, if I have to use that word, that it is draconian, because there are so many other things which are there, and you don't have a punishment on those scenarios where you put them behind the bars for 3 months. That's
Dr.
something which
Bhatia,
is
also explain to us, what kind of impact does this have on mental health of young people, especially the ones who are in transgressive relationships that are not accepted by society? A law like this scrutiny, what kind of impact does this have on the mental health of couples?
Absolutely, it will have an impact. That's why I said it, that do not touch on that aspect. Let there be, because there has been already a law in place where they have given recognition to relationship. They have given recognition to the aspect of domestic violence, where they have given recognition in aspect of alimony. In also UCC is also talking about giving legitimacy to illegitimate child and equal rights to an illegitimate child. So let there be an aspect covering all those.
Dr. Bhatia, would you agree with that? What about the mental health and the thing that Ms. Jain is also pointing out?
No, this is absolutely traumatizing and stigmatizing, because I was just saying that how would go household by household and check whether people have registered and whether they have the marriage certificates. So it can actually have very severe ramifications, and just like the criticisms of anti-Romeo Squad, where even couples who were brothers and sisters were targeted. And this whole thing of prohibited relationships, it's a very problematic term, because again, if they are consenting adults and they have entered into,
Dr. Bhatia, thank you.
In Shakti Vahini versus Union of India, Lata Singh.
I'm really sorry, we're running short of time. Thank you, Dr.
Srivastava.
Thank you, Mr. Srivastava. Thank you, Dr. Bhatia, and thank you, Ms. Jain, for joining us on this discussion. The UCC has been brought in Uttarakhand. It's being discussed, and it could soon become a law. Also joining us now is Nalin Kohli, who's a senior advocate and also a member of the expert committee that recommended and drafted the law proposing to ban polygamy in the state of Assam. Thank you, Mr. Kohli, for speaking to NDTV. Sir, India was known for its litany of personal laws, with each religion following its specific regulations, specifically when it came to personal matters, marriage, inheritance, divorce, etc. Now, Uttarakhand's UCC, what does this mean for the country? Will other states also follow suit? And what does this mean for the plural character of this country, that UCC could actually become a reality?
That's a good question, Masudha, because we need to understand carefully why the need for a uniform civil code as a fundamental point. So please bear in mind that in 1950, when the Constitution of India was adopted on 26 January 1950, in Chapter 4, Directive Principles of State Policy, Article 44 clearly says that the state shall endeavor to have a uniform civil code. The state is defined as either as the union or the states or union territories. Next, Article 37 makes it clear that the directive principles cannot be enforced by a court. But most people who point this out fail to recognize that within Article 37 lies a duty on the state to also include these principles in the drafting of laws. Therefore, Uniform Civil Code is a constitutional vision that existed or has existed in the Constitution from the days of its drafting to its adoption in 1950 till now. It is part of the Constitution. It's an unfulfilled vision. Therefore, there is no impediment, or there cannot be an argument that you shouldn't have a uniform civil code. Because what is good, what is in the Constitution is for the welfare of Indian citizens. Nothing in the Constitution can be bad for a citizen. And no citizen can take an argument that I like one part of the Constitution, I will accept that, honor it, but I don't like another article and I would not like it to be implemented. So I think the confusion that is created on the subject of Uniform Civil Code primarily comes from those individuals who A, haven't read the Constitution, B, who are moving away from the constitutional mandate to a political or a personal and trying to intertwine it with a religious mandate.
Right. Mr. Kohli, the bill also aims to in some ways regulate live-in relationships. In fact, it makes it obligatory for partners in a live-in relationship to register with the state. Many would say in a society like ours that's not often pro-love, young love, actually adolescent love, this could have been avoided, as it gives more power to the state and families as opposed to the individual's rights.
So Vasudha, it's an interesting question and you pose it to me as a practicing lawyer. So I am bound also by the discipline as a lawyer, but I must point out a few things. One, a proposed bill will become an act of the assembly or will be passed by an assembly after debate or by the parliament as the case may be, is always open to a legal challenge. Prior to the legal challenge, there is always the possibility that something may stand amended or the rules may specify the procedure in the manner in which a certain intended section is to operate. So there may be a section that may put out the vision and put out what is to happen, but the rules may subsequently be drafted to tell the mechanism and the requirements of meeting, a violation of that will lead to the section becoming applicable. Third, there is everything finally will flow from what is constitutionally permissible and in terms of the guarantees that exist on every every guarantee that is under Part 3 or the fundamental rights of every citizen under Part 3 of the Constitution of India. So obviously, right to equality, right to life and liberty, all of this comes into that gamut. However, there are other rights also, the right to protecting life and liberty and not the misuse of it, as often this comes up in debates relating to inter-religious marriages and the question of fraudulent conversions, coerced conversions, which are not free will. So that's one aspect also that is real and the courts haven't come in. I was only today looking at a news item that on the issue of surrogacy, a single mother, a lady has wanted to be a surrogate mother, and the courts have said that what may apply to the Western context may not necessarily apply to the Indian context. So we have our social and our cultural, world in which we live, and the courts are not divorced from that. So I think a balance is done. With regard to live-in relationships, I think I haven't read the act or the bill, and my own guess is it flows from protecting women's rights in terms of no fraudulent or issues that may come up. It may also have to do with the fact that marriage is broadly now recognized, and perhaps it can get amended in the future, I don't know. But, there is a certain age to adulthood and then marriage. So there is perhaps the risk of an adolescent relationship culminating, say, for example, into a childbirth. That creates further rights on children, etc. So I think we should look at it from the beneficial perspective rather than from the perspective of trying to restrict. But however, in a beneficial approach also, everything is always open to evolution and under due process, even legal scrutiny. So we need to hold our horses in that sense before we arrive at a conclusion, this is it, this is good, this is bad. Till it's passed, then let us see what's the discourse, how do the rules come out, if any rules are to come. We need to hold our horses.
Thank you, Mr. Kohli. So that's all we have.